Good morning, guests. Thank you for joining us today for the updates on the Singapore Personal Data Protection Act. My name is Hitan. I'm a member of the ICT committee within the British Chamber. This event is actually being brought to you from the ICT committee. A little bit about the ICT committee. It's our mission to inspire, educate, engage Chamber members and non-members on the transformative capabilities of IT to their business. The goal of the committee is to add value back to the Chamber and its members through activities that demonstrate the value of ICT solutions to their business, educate them on the future ICT trends that will impact their business, offer member networking opportunities to really better enable them across the region, and to share knowledge and insights and attract new members to the Chamber. So today's event, we're very lucky to have an update to the enhanced PDPA, which came into operation in February 2021. It expands on the ability of organisations' use of personal data, while also increasing accountability for data breaches. Notably, it introduces a mandatory breach notification framework, expanded exceptions and deemed notification framework allowing personal data to be used without consent. Further changes in relation to the introduction of data portability regime are also expected to be operative in the near future. And really it's about learning about the PDPA and how really the pitfalls and new requirements that you can bring back to your business. And with no further ado, I will introduce the speakers. So we have Janice from Cavenagh Law and also Lena from Clifford. So if I could hand over to the speakers. Janice,
thank you, Hitam. Yep. Thank you, Hitam. I'll start first. And on behalf of Clifford Chance, thank you to the British Chamber of Commerce for inviting us to present at today's session. Could I have the next slide, please? Thank you. As this session is being recorded, our firm's policy is to include the slide as a standard disclaimer, which generally states that the content in this session is generic and not meant to be legal advice, and the content may be outdated when the recording is played. Thank you. Next slide, please. So we'll just have a quick kickoff question for polling. You'll be invited to choose from the various options A, B, C, D. The question is, does your organization have a data protection policy which specifically applies to Singapore? And the various options, as you can see there, A, no, we have a global data protection policy, but there is an addendum. B, no, we have a global data protection policy, but there's addendum which applies to Singapore. C, yes, there is a specific data protection policy for Singapore. And D, no, we don't have any data protection policies and we don't need one. Someone else takes care of it for us. Please select from A, B, C, D. And when we get the polling details in, we'll see how we did there with the attendees. Sabina, do we have the results? All right, interesting stats. So in Singapore, I mean, I think all of you would be from organizations that are, carrying on business in Singapore, based in Singapore, and we have a data protection policy requirement. It may not be necessary to have a specific policy for Singapore. And in practice, it's common for multinational corporations to have a global data protection policy, which would then be or should be reviewed for compliance with Singapore law. And sometimes the policy would have an addendum at the back or a section that just says, okay, this bit supersedes the previous bit for Singapore. So in terms of the questions, the correct answer should have been any of A, B, or C. I see we have a few Ds. We do hope that those organizations do have a policy. One thing to note is that we've had lots of questions about, GDPR, and we have a lot of clients who, base their policies on GDPR. And, what are the differences between the two policies? So the main difference, very, very high level, is that GDPR tries not to rely on getting specific consent from the relevant individuals. In fact, they rely very heavily on something called legitimate interest. The PDPA, however, is still very largely consent-based. Now we're going to talk about some of the sort of uplifts to the PDPA, which includes including certain features that helps bridge the differences between GDPR and PDPA, and we'll talk about this later on. As we know, one of the key amendments to the PDPA that came into play, as Sita mentioned, in February 2021. So there are still these differences between, I'm just giving an example to GDPR, but there are other jurisdictions that obviously have their own personal data law. One cannot really say I'm compliant with GDPR or other jurisdictions, and so I must be compliant with Singapore PDPA. So understanding the key differences is actually quite important, and hopefully we will help you understand those today. Can I have the next slide, please? The next slide shows the agenda. We'll kick off with some recent data and cyber incidences to hopefully share with you, why it's important to understand the law here in Singapore and general data privacy law. The PDPA has actually been in play in Singapore for a number of years now. It went through its first major revision in February, and we'll cover the key amendments in our session. We will also cover some common issues and pitfalls that we see in practice, and also some enforcement cases. We'll just go through, after that, some cybersecurity issues and managing cyber risk. Now, there's a lot of content on this slide. We don't have enough time to go through every slide in its every detail. We might skip through a few, but please do read the slides at your own time after the session. Could we have the next slide, please? So this slide shows some high-profile cyber incidences in the last couple of years. Data hacks, as you can see, involves compromise of personal data and sometimes can amount to millions of customers or individuals. And there is a high cost to these organizations, going to hundreds of millions of dollars. And this is a real issue for organizations. These cases have happened, and it could happen to any organization, whether large or small. And there's a common saying, it's not whether you get hacked, but when you get hacked. Next slide. So the implications of a cyber attack could be more than just pure loss of data. It could result in loss of services. So if you've been seeing the headlines, stoppage of oil pipelines in the recent attack in the US on Colonial Pipeline, it could also result in impacts on your life, right? Hazardous effects because of hacking into water systems that poisons the water that we saw in February in Florida. And here in Singapore, we've also not been spared that all these headlines did appear in the newspapers and have impacted people and businesses in Singapore. So next slide. So we're going to go through maybe the next one, very quickly, the PDPA. As I mentioned, there are a few changes that we'll go through. Just a quick recap. There might be people who are not familiar with the PDPA. Sorry, next slide, please. And we want to just make sure everyone's kind of on the same page. So I think one key question that we're always asked is, who does the PDPA apply to? So all organizations that collect, use, and disclose personal data in Singapore would be subject to the PDPA, and it's very broad. It has some extraterritorial application as well. There are some exceptions, as you can see in the middle of this slide. Government agencies are subject to different law. It's not that they're fully exempted. There are certain types of organizations that carry on certain activities that may have a smaller segment of the subject to the relevant law, PDPA. Employees, to a certain extent, when they're doing work for the employer could be exempted, but the employer, I think that's important, the blue box at the bottom, they are liable for the acts of its employees unless the employer can show that it took practical steps to avoid the employee from carrying on those acts. So that's why, the employers, the organizations would have policies, they would have training manuals, they will go to an annual training to show that they have, considered the PDPA, they've trained the employees. And so, if something happens, they can perhaps try to defend themselves from that perspective. Next slide, please. Next slide is, again, a very common question we get, what is personal data? And as the slide says, it's data, and it's whether true or not about an individual. So it has to be a human being, not a corporate, that can be identified from that data, or from that data and any other information that the organization has access to. So there are some carve-outs. So business contact information, sort of the information that you would see on a business card, is not personal data. Where the personal data has been in existence for a long time, that could be excluded. It also, in Singapore, and different from some other jurisdictions, it also includes information about a deceased individual, unless the person has been deceased for a certain number of years. Next slide, please. So the personal data is not intended to be narrowly construed and can take different forms, whether on a piece of paper, video, your passport, your NRIC, etc. And as I mentioned, it's not just that personal piece of data. If you can, even if it's anonymized, but you have the key to de-anonymize that data, you could still be sort of held to be holding personal data. So we do a lot of advice in relation to anonymization, and it can be a very tricky legal as well as technical question. Next slide, please. Next slide, please. Oh, sorry. I'm looking at the wrong slide. Previous slide, sorry. Yes, so just to mention, who takes care of the PDPA, there is a commission called the Personal Data Protection Commission. They're established under the Act itself, and they're the ones that will basically set up the, they're in charge of the Act, the regulations, issuing all sorts of guidelines, notices to the public. They also provide training, etc. And they have for people who are looking after personal data, they actually have a bit of a interesting section where you can actually read a lot of their decisions in relation to potential breaches that have taken place in the past. Sorry, next slide. Yes, so this is important concept, as we mentioned, that the PDPA is very much still a consent-based regime. The main rule is that organizations must obtain consent of the individual before it can collect, use, or disclose personal data, unless an exception applies. Now, in obtaining the consent as well, the intention is that the organization must notify the relevant individual of the purpose for which it is collecting, using, or disclosing the personal data. And you must get that consent before you collect, use, or disclose, again, unless certain exceptions apply. Now, the exceptions in the PDPA are generally quite limited. Well, at least before the amendments in February, there were some baseline amendments, for example, where it's necessary for legal proceedings or investigations, or where it was necessary for life-threatening emergencies or safety situations. But in February 2021, this was expanded to have a wider exception to the consent framework. Partly the motivation was, as I mentioned previously, to make it more interoperable with other data protection regimes that apply. And for a lot of multinational organizations, they do are subject, or they do subject themselves to GDPR, which have these non-consent based regime. So for example, there is a new deemed consent for contractual necessity. And the idea is that in order for you to perform a contract between the organization and the individual, the organization it may be able to rely on deemed consent if it's notified the relevant individual and that individual has not opted out. However, in relation to this exception, and similarly for some of the other exceptions that we'll talk about, there's a requirement for the organization to do some homework first. It has to conduct a risk assessment to determine whether this new way of collecting will have an adverse effect on the individual. So it's not simply something that they can just tick the box. There will be some due diligence and consideration by the organization before they can rely on this new these new carve-outs. Next slide, please. So as I mentioned, there are these other, I mentioned deemed consent, but there are also other new carve-outs from the consent regime. And I mentioned again GDPR because that was a big driver for some of these changes. In GDPR, there is a carve-out called legitimate interest, and these changes here on this slide, the new legitimate interest exception and the business improvement exemptions are sort of inspired, I guess, from those changes. So if you do fall within these exceptions, you do not need to get the consent of the individual. However, again, as I mentioned, there is homework that has to be done by the organization before they can rely on these exceptions. They do need to do the risk assessment. So for example, for the legitimate interest, they need to ensure that the interests of the organization outweigh the adverse effect on the individual without getting the consent of the individual. And the business improvement exception, the idea that they can use personal data to improve or develop goods or services or operations or learn or understand preferences about the individuals. Again, they have to do this risk assessment to determine that the benefits outweigh the risk to the individual. Next slide. So the thing about consent is that there's ability to withdraw. So where you are relying on consent, the relevant individual can withdraw consent. So this was the position even before the changes earlier this year. And an organization cannot prohibit the individual from withdrawing his consent. However, they can or they have to inform the individual of the consequences of withdrawing his consent. Next slide. And so alongside the obligations alongside the things that the organizations need to do, they also have given the individual certain rights under the PDPA in relation to his or her personal data. So for example, the right to request information or access to the personal data that are held by organizations. There are certain exceptions which I don't propose to go through today. These were already in the PDPA before the changes that took place earlier this year. There's an ability for individuals to request the organization to correct inaccuracies, and there's also a baseline requirement for organizations to also provide the individual with details of third parties to whom the information was disclosed for the prior year before that. Next slide, please. So again, under the PDPA, there are also obligations on the organization to protect the personal data that it is in possession of, ensuring there's reasonable security arrangements. They also have to ensure the personal data is accurate and complete. So I'm sure everyone attending has received information from your bank, for example, asking you from time to time to check your personal data. And there are also retention limitation periods. So this is an interesting one. As a law firm, we're always asked, how long must I keep the information, plus how long can I keep that information? So this question here is how long can I keep the information? Because the Act actually restricts organizations from keeping information forever. There's an idea that you should only be able to keep the personal data for no longer than is served, for as long as there are sorry, let me repeat that. It should only be retaining data for as long as they're business purposes, and is you should actually dispose of the information once it is reasonable to assume that you don't need that information anymore. Next slide. So one last obligation that I want to discuss in a bit more detail. This is called the transfer limitation obligation. And there's a similar concept for example, under GDPR, that basically if you transfer that information out of Singapore, then the organization has to comply, has to ensure that the same level of protection is accorded to that information. Now, there's a lot of detail that goes into this. All I would say is that this is the one that sometimes is missed by a lot of our clients, and we have to remind them that it's something that it isn't just dealt with in the policy, but they will have to look at whether they have, for example, intercompany arrangements or agreements that are legally binding, or service level agreements with their service providers that deals with this obligation. Because if you do hold the information, you transfer it to a third party, you have this obligation under the PDPA. And in a practical sense, is usually dealt with by contractual provisions to ensure that the person to whom you're delivering that information, treats the information in a certain way so that you, as a transferor, are in compliance with your obligations under the PDPA. Next slide, please. Now, the PDPA also provide for certain obligations that are more internal facing. So for example, there's a requirement under the Act that for each organization there must be at least one officer or personal data protection officer that is appointed, and you must have policies to show that you are in compliance with the PDPA. So that leads back to that first question that we asked you, whether you do have a policy. Generally, if you're an organization collecting information in Singapore, and if you have employees, you would be collecting information in Singapore, then you should have a policy to deal with how you deal with personal data. Now, let me hand over to my colleague, Janice, who will take us through the next section. Over to you, Janice.
Thanks very much, Lena. So, if an organization outsources its data processing activities to another entity, that entity processing the data for and on behalf of the organization is a data intermediary. So let's look at engaging data intermediaries and the obligations of data controllers here. And the data controller being the organization that engages the data intermediary. So data processing mainly includes the recording, holding, organizing, adapting, or transmission, etc. of personal data. So it is important to note that engaging a data intermediary does not absolve the data controller of its obligations in relation to personal data. So this means that if a data breach, including a cyber hack, occurs at the data intermediary while it is handling the data controller remains responsible for the breach. This is because the PDPA states that data controllers shall have the same obligations under the Act in respect of personal data that is processed for and on their behalf by a data intermediary, as if the personal data were processed by the organization itself. So this is becoming increasingly relevant and important as many recent cyber hacks are carried out on vendors. So it is not just about the security of your company that you should worry about, it's also about the security of other companies that you do business with. So a high-profile example of such a hack on third-party vendors is the Target hack in 2013. It was one of the examples in the earlier slides, where Target paid USD $18.5 million to the US authorities in 2017. So in that case, the payment accounts of about 41 million customers and the personal details of around 70 million individuals were hacked into. So investigations revealed that the hackers gained access to one of Target's vendors, which supplied aircons and refrigerators to Target via phishing emails, and they stole their login credentials to Target's systems. And the Targets then exploited the system. The hackers then exploited the systems to gain access to Target's customer service database. So the onus is on data controllers to do due diligence to ensure that the chosen data intermediary is capable of complying with the PDPA. Data controllers are expected to follow through with procedures to check that the outsourced provider is delivering the services. So in addition to due diligence on the data intermediary, the agreement between the data controller and the data intermediary should also clearly set out the scope of processing and the permitted and prohibited uses of personal data by the data intermediary. Next slide, please. So what are the obligations of a data intermediary then? So as mentioned earlier, a data intermediary is an organization that processes personal data for and on behalf of another organization. It is not subject to the full suite of data protection obligations in the PDPA. It is only subject to 3 obligations, namely the protection obligation, the retention limitation obligation, and the breach notification obligation. So this breach notification obligation is a new amendment to the PDPA. It came into effect in February 2021. We'll cover more of it in detail later. But just to elaborate now that a data intermediary is required to notify the data controller of the data breach, but it does not need to notify the PDPC or the affected individuals. That responsibility lies with the data controller, not the data intermediary. So what if the data intermediary uses or discloses personal data in its possession or control, but is beyond the remit that is granted by the data controller? So in this case, the data intermediary will be responsible for complying with all the data protection provisions, because it is no longer simply just using the personal data for and on behalf of the data controller, it is using it for itself. So this again underscores the need for a clear agreement between the data controller and the data intermediary, which sets out the permitted scope of use of data by the data intermediary. Next slide, please. Some practical tips on how to engage a data intermediary. This is guidance that has been issued by the PDPC. So it is important to understand a data intermediary's management lifecycle. First, to conduct a governance and risk assessment, establishing the objectives and requirements for the proposed outsourcing and understanding the risk involved. It is good practice to evaluate the potential data intermediaries' data protection framework, including their policies, practices, and training for their staff. Second, policies and process practices. The data controller should have a binding contractual agreement with the data intermediary in writing to clearly define the scope of the outsourced data processing activities and the data intermediary's obligations and responsibilities in protecting the data. There should also be clear communication channels established with the data intermediary. Next slide, please. Third, on service management. An accountable data controller not only develops and communicates its data protection policies, it must also put in place monitoring and reporting structures to manage the data intermediary. So for example, developing an onboarding process, ensuring that the data intermediary's personnel are aware of the data controller's business requirements, and to carry out audits and on-site inspections. Lastly, there is the exit management process. Data controllers should establish exit management plans for the conclusion of the engagement of the data intermediaries to ensure business continuity and proper handling of personal data. Next slide, please. Yep. So now we come to the new obligation that is effective in February 2021, along with the new amendments, which is a mandatory data breach notification. So what is notifiable? So the mandatory data breach notification obligation requires organizations to notify the PDPC and or affected individuals if the data breach, first of all, whether it results in or is likely to result in significant harm to an affected individual, or second, if it is likely to be or it is of a significant scale. So we'll refer to these as notifiable data breaches. Organizations are required to assess whether a data breach is a notifiable data breach. But please also note that there are certain prescribed personal data and prescribed circumstances which are deemed to amount to a notifiable data breach. And this is the case even when the number of affected individuals may be low. So prescribed personal data or prescribed circumstances amounting to deemed significant harm include where the data breach relates to sensitive data or financial data, such as medical information or bank account details. And a data breach is deemed to meet the criteria of significant scale if it involves the personal data of 500 or more individuals. So who to notify? Organizations are required to notify the PDPC of data breaches of significant harm and data breaches of significant scale. For affected individuals, they only need to be notified of data breaches of significant harm, and they do not need to be notified if an exception in the PDPA applies. So these exceptions are set out in the right-hand column of the slide. For example, if there's timely remedial actions taken by the organization that renders it unlikely that the data breach will result in significant harm, or if there has been appropriate technological measures applied to the personal data, such as encryption with passwords, before the data breach that will render the personal data inaccessible or unintelligible to an authorized party, where the PDPC instructs the organization not to notify the relevant affected individuals, perhaps because it does not want to prejudice existing ongoing investigations into the hack. And of course, if the PDPC waives the requirement upon a written application of the organization. So if any of these exceptions apply, the organization is not required to notify the affected individual of the data breach. Just to quickly touch on when to notify the PDPC or affected individuals, organizations need to notify the PDPC as soon as practicable, but in any case, no later than 3 calendar days. Where an organization is required to notify affected individuals of notifiable data breaches, it should do so at the same time or after notifying the PDPC. Next slide, please. Data portability obligation. So the Singapore Parliament has passed amendments to the PDPA to introduce a data portability obligation, where organizations must, at the request of an individual, transmit his or her personal data to another organization. However, this is not effective yet. It will come into operation at a later date. And at this stage, the PDPC has not announced when the data portability obligation will come into force. Next slide, please. So we'll now cover the do not call registry, or in brief, the DNC registry. So in addition to the data protection obligations that we have just gone through, the PDPA also establishes the DNC registry. So what is the DNC registry? Essentially, individuals may register their Singapore telephone numbers on the DNC registry if they do not wish to receive marketing messages on their phone. Organizations will then be prohibited from sending marketing messages to a telephone number unless consent of the individual is obtained. So if the organization has not obtained such consent, it must check the DNC registry to determine whether the number is on the DNC registry. And if it is, it cannot send marketing messages to that number. So the DNC registry will only cover calls, messages, or faxes sent to Singapore telephone numbers. It does not cover emails or hard copy mail, not because those are not relevant, but they are covered under other legislation in Singapore, such as the Spam Control Act. The next slide, please. So there are certain exclusions in the PDPA which allow organizations to send messages to Singapore phone numbers, even if there is no consent or if their numbers are registered with the DNC registry. These are the exclusions. For example, if the organization needs to send a message that is necessary to respond to an emergency that is life-threatening or threatens the health or safety of any individual, or if the message sole purpose is to provide warranty information, product recall information, or safety or security information on a product or service that has been purchased by the user. Any message, the sole purpose of which is to conduct market research or market survey, and any message sent to an organization other than an individual acting in a personal or domestic capacity for purpose of that organization receiving the message. This is your B2B, business-to-business marketing messages, for example. Next slide, please. So we'll now cover offenses. In terms of offenses, under the PDPA, the organization is, of course, liable for breaches. But before we cover the offenses applicable to organizations, we highlight that the PDPA was amended in February 2021 to introduce offenses on individuals. So the aim is to target individuals who know that their actions are not authorized or who act recklessly. So in these cases, such persons may be liable for a fine not exceeding Singapore $5,000 or imprisonment for a term not exceeding 2 years or to both. Next slide, please. So in addition to offenses relating to the breach of the personal data protection obligations, the PDPA also sets out offenses for falsifying or changing personal data without authority, or if the PDPC's investigations are obstructed, or where false information is given to the PDPC. Next slide, please. So where an organization breaches the data protection provisions in the PDPA, the PDPC may investigate and enforce penalties against the organization. The PDPC has clarified that it is a complaints-based enforcement. In other words, it is more of a fire alarm patrol rather than police patrol type of regulation. So in terms of the types of penalties that the PDPC may impose on organizations for breaching the data protection provisions, the PDPC may issue directions of a wide range. So they may range from directing organizations to cease use of personal data, to carry out certain remediation measures in terms of its data use, and it may also direct that financial penalties be paid. The PDPC may also apply to register its directions in a district court, in which case those directions will have effect as if it were a court order. So non-compliance of a court order will result in contempt of court. We flag that the Singapore Parliament has approved that the maximum financial penalty on breaching organizations will be increased from $1 million to 10% of the organization's annual turnover in Singapore, or up to 1 million, whichever is higher. But this is not enforced yet, and it will be effective at a later date. This type of penalty regime is already present in other legislation where it's tied to the revenue. For example, in the Competition Act. Needless to say, this significantly dials up the severity of the penalties. Next slide, please. We also want to highlight that there is a lot of useful guidance that has been published by the PDPC, and they're available on the PDPC's website. We won't go through them in detail, they are on the slides, but one example is the PDPC's guide on managing and notifying data breaches. Next slide, please. So another useful guide is the PDPC's guide to developing a data protection management program. Next slide, please. So we will now talk about some common issues and pitfalls that both Lena and myself have seen in practice. So Lena mentioned just now that the transfer limitation obligation is quite tricky. We have seen some of the organizations trying harder. It's more challenging for organizations to comply with. So to recap, the transfer limitation obligation states that personal data cannot be transferred to a foreign recipient unless the transfer limitation obligation is complied with. So in practice, this is usually achieved via binding corporate rules or legally binding agreements, as Lena went through just now. So in terms of what we see in practice, in our practice area, we do a lot of, for example, investigations, or for including cross-border investigations, where there would be practical issues with sending the personal data in documents that a foreign regulator might request. Of course, depending on the intensity and how aggressive the foreign regulator is, it is probably going to be unlikely that a foreign regulator is going to agree to enter into a legally binding agreement with the entity investigated to protect the personal data to a standard that is comparable to that under the PDPA. Of course, it may be possible. It differs from a case-by-case scenario, but we just want to highlight that this is something that we have seen in practice, where organizations will then have to determine, the competing obligations under various different laws and decide which one they will need to comply with and take a risk-based approach. The other issue that we have seen sometimes is about using how to use personal data to terminate employees. So the PDPA provides that notwithstanding the application of an exception in the PDPA, an organization must, before collecting, using, or disclosing personal data about an individual for the purpose of managing or terminating the employment relationship, they must inform the individual of that purpose. So some interesting issues we have seen in practice. For example, we have come across a case where a client had some CCTV footage that was recorded primarily for security purposes. And in the personal information collection statements and agreements with the individual has provided his or her consent that CCTV footage of himself or herself may be recorded for security purposes. Now, can the organization then use this CCTV footage as evidence to terminate an employee for misconduct? For example, he was absent, or he did not come in, or other types of misconduct that's been recorded on the CCTV. So it's tricky. If you have not obtained his or her consent for the CCTV footage for purposes of managing or terminating an employment relationship, there needs to be a broader analysis that's to be carried out in relation to whether you can use the personal data in the security footage or not. Next slide, please. So we'll now go through some recent enforcement cases. The first one, MSIG Singapore, an insurance company, and another. This is a good example of a data breach by a data intermediary, where the PDPC investigated into the matter and found that the data controller was not responsible for the breach. So in this case, GSI, a company called Global Sign Private Limited, they run an email marketing platform, which is used to send mass marketing emails to email addresses supplied by its clients. So the insurance company, MSIG, had engaged GSI to send marketing emails to its customers via this platform. So the administrator account of the platform was accessed without authorization, which resulted in spam emails being sent to a number of email addresses, which led to compromise of personal data. The main issue was whether MSIG, as the data controller in this case, and GSI, the provider of the platform, being the data intermediary, had done enough to protect the personal data in their possession or under their control. So the PDPC found that MSIG did comply with its obligation to protect personal data and so did not breach the PDPC. MSIG had, in its agreement with GSI, imposed security requirements on GSI, and MSIG also had the right to inspect and audit GSI. MSIG had followed through with these contractual obligations in practice with operational processes, such as asking GSI to purge email addresses provided by MSIG from GSI's systems. In contrast, GSI, as a data intermediary, was found to have contravened its obligation to protect personal data. The PDPC found that there was no password expiry mechanism, and password strength requirements were also not enforced. And it also found that all users of the administrator account shared the same account and login credentials, which is of course a big no-no in today's security standards. A financial penalty of 34,000 Singapore dollars was imposed against GSI. So we go to the next enforcement case now, which is a recent case against Singapore Technologies, and it relates to the transfer limitation obligation. So in this case, the US-based subsidiary of Singapore Technologies was hit by a cybersecurity incident where threat actors gained unauthorized access to its IT network and deployed a ransomware attack. So Singapore Technologies network in Singapore was not compromised. However, personal data of 287 individuals in Singapore were potentially exposed, and these data were transferred by Singapore Technologies in Singapore to its US subsidiary. So upon discovery of the incident, both Singapore Technologies and the US subsidiary notified their respective regulators and undertook remedial actions. And the PDPC found that and clarified that the US subsidiary was not subject to the data protection obligations in the PDPA because it did not carry out any collection, use, or disclosure of personal data in Singapore. So the issue was really whether Singapore Technologies' transfer of personal data to the US met the transfer limitation obligation under the PDPA. The PDPC held that Singapore Technologies had complied with the transfer limitation obligation, and there's no breach of the PDPA because Singapore Technology had put in place binding corporate rules for the transfer of personal data. And these binding corporate rules applied to and were legally binding upon all its group companies worldwide, including the US subsidiary. The binding corporate rules specified the countries to which personal data may be transferred, which is a requirement under the PDPA and its regulations. Each group company that received personal data was bound by legally enforceable obligations to provide a standard of protection for personal data transfer that is at least comparable to the protection under the PDPA. And the rights and obligations provided by the binding corporate rules are specified. For example, permitted purposes of how transfers may be made and relating to the security and protection of personal data. So now on the next section, containing risk. Next slide, please. Thank you. And next slide, please. So how can organizations try to ensure compliance with the PDPA and minimize data breach? Here are some best practices. Security strategy and due diligence is key to scope and identify personal data storage and processing activities. A security risk assessment must be prepared and to conduct a gap analysis of existing policies and procedures against the PDPA. To ensure preparedness in dealing with a data breach, there should be adequate incident planning. Cyber response policies and procedures should be prepared and updated. Material contracts should be identified. There should also be security testing and training. And do also contact your legal advisors, whether they are internal or external legal advisors, as they can advise on the regulatory requirements, review of the response plans, breach notification requirements, and legal remedies. Next slide, please. So some further practical tips in best practices. The key really is to have a solid and clear cyber response plan and an intimate knowledge of your data flows. The best way to address this risk is to know your exposure, both operationally and from a regulatory perspective. So what does this mean? There must be a cyber strategy and due diligence conducted before an attack takes place. An organization should map data flows to systems and data exports to other countries, and to identify where data resides, including identifying sensitive data. This will then form the basis of a cyber readiness plan. The plan will need to be audited and updated on a regular basis as legislation changes, data flows may change, and third parties may also change. Next slide, please. So we'll now go through a hypothetical case study which Lena will bring you through.
Thank you, Janice. I hope everyone can still hear me. Okay, so we have a hypothetical question here. The scenario, Sabina, if you can turn on the voting for attendees. So the question is, emails relating to one employee's recent absence from work, which includes medical information, is sent by another employee to the wrong distribution list, and the distribution list contains over 200 people, some internal and some external. So our question, just to test that hopefully you were following our presentation, does the organization need to notify PDPC of the breach? If people can start voting. And hopefully, Sabina, we can see the results. Yes, great. People were listening. The answer is yes. Medical information is deemed to be data that results, so it's likely to result in significant harm under the PDPA. And so the PDPC should be notified. We're trying to sort of test people's understanding. There was only one individual affected, but PDPC should nevertheless be notified. So I'm glad that most people got that right. Question 2 now, next slide. Same scenario, the organization then investigates into the matter and determines that the distribution list comprised only 3 internal staff that worked in a different business department from the relevant employee that had the fat finger. The distribution list did not contain a list of information relating to 200 people, internal and as previously reported. So, after investigation, they found different facts. Does the organization need to notify PDPC of the breach? Please vote. Sabina, please turn on the voting. Thank you. And if you have the results. All right, some less sure. So the answer is yes, because medical information, if you recall from the first slide on the questions, is deemed data that results, so it's likely to result in significant harm under the PDPA. In this case, even though there was only one information on one individual, that was affected, and only 3 recipients of the data, because they involve medical information. The PDPC, should be notified, at least as set out in the Act. So if we can go to our third question. Does the organization need to notify the affected individual of the data breach? In this case, reminder that the data was only sent to 3 internal staff. If you can vote, and we'll see the results as soon as it's available. Good. Yes, mostly everyone got it right. Medical information is deemed data that, repeating myself again, but results or is likely to result in significant harm. So the affected individual should be notified. Although there is only 1 individual and only 3 recipients, again, because of the information being, medical information, affected individuals the affected individual is required to be notified. Thank you. That comes to the end of our questions. But we actually got questions from the floor. So we do want to answer as many as we can. So looking at the question, I think that there's some that can be answered very quickly. There was a question from an anonymous attendee. Does DNC provision apply to email addresses as well? So the answer is no. The DNC provisions apply to phone numbers or mobile numbers or fax numbers, if anyone's still using a fax machine. But there is the question has been removed. But the thing to note is there is another act called the Spam Control Act that actually would apply to people who are sending multiple messages to many email addresses. So there is something else, another piece of legislation that deals with sending marketing messages to email addresses. Now, there's another question. Must we notify customers before we use their data under the business improvement exception? Can we send the data to third parties for processing under this exception? Will there be a consent required? So I think there are sort of 2 embedded questions here. I think if we can take people back to slide 33, I don't know, Sabina, if you're able to, sorry, not slide 33, slide 31. Oh, sorry, no, sorry. Let me get the right slide before yes, slide 13, sorry. The business improvement exception is actually quite a narrow exception. Is really an exception for people who are wanting to use information for a certain purpose for which I think they did not get the individual to consent, and this relates to the business improvement purposes. And so it's actually quite a narrow exception because it's in relation to the use of the information for business improvement purposes, and it covers the sharing of information within the organization and also with related corporations within the group. But that said, the PDPC has actually separately commented in something called the Guide to Data Sharing, where interestingly, they actually stated in this guide that an organization may share personal data with its data intermediary to process personal data on its behalf. They recognize that to ease business decisions on outsourcing or operations, express consent is not required for an organization to disclose personal data to its data intermediaries, but the organization has to put in place a written contract with that data intermediary, something that I think Janice covered earlier when we talked about data intermediaries. Now, that's the only place that I'm aware of that the PDPC has actually said that. I think it's a practical recognition of the difficulty of getting consent for disclosure to data intermediaries, and data intermediaries, you have to have that contract with the data intermediary, and the idea that the data intermediary is only processing within ways in which you are able to anyway. But in practice, what we usually do is to ensure that we try to also cover it with consent, because I think that provides a clear pathway to being able to disclose that to data intermediaries. Janice, do you want to cover the other question which was giving an example of a situation where the expanded deemed consent will be applicable. There's a very helpful example that the PDPC has given of such an example, and maybe perhaps read that out to the audience. I think that will give people a very clear example. Janice?
Yeah, sure. So the PDPC has shared this example in the guidance where it relates to a hotel's sharing of personal data with partners. So for example, a hotel chain wishes to rely on deemed consent by notification to disclose personal data of its members. This includes, for example, frequency and length of hotel stays, type of rooms, preferences, and reviews to a travel website company in order to develop online travel resources and customized travel packages. So the personal data that it shares with these travel website company will not be used to obtain consent for sending direct marketing messages to members. So the hotel chain assesses that there is no likely adverse effect to its members in disclosing their personal data for this limited purpose. And the hotel chain also assesses that emailing members on the intended sharing of their personal data is an appropriate and effective method of notification, as it regularly sends emails to its members regarding membership points and rewards. And it also assesses that providing members with 10 days for individuals to opt out of this use of data is a reasonable period. So the hotel chain then sends an email to its members, notifying them of the intended disclosure of their personal data to the travel website company for this purpose, and provides a contact number for any queries on the intended disclosure. So a hyperlink is provided in the email for members to opt out, and the hotel chain requests that members who wish to opt out should do so within 10 days. So members who do not opt out within the 10-day opt-out period are deemed to have consented to the collection, use, and disclosure of their personal data for this purpose. So that's a useful example that has set out how the deemed consent by notification framework applies in practice.
Thank you, Janice. There was a last question, which I think there was a request for us to answer that live. The question was about business contact information. Yes, correct. Business contact information is not considered as personal data, but there's a question whether you could use business contact information for marketing. So I think around that, you have to consider the DNC, the Do Not Call provisions, and also the Spam Control Act that I mentioned. And then you have to consider whether when you're sending, notwithstanding that you have the business contact information, the question becomes whether you are sending that marketing message to that person in the role as in his business or as an employee of that company for which he has the card, or maybe he has also given you the business card more as a personal contact. For example, he's gone to a gym and he's using his business card. It doesn't mean that just because it's business contact information that then if you send personal marketing messages to that number, you're then exempt from the DNC. So I think there are some factual questions that have to be considered around that question, and there isn't just a one-off blanket answer to that particular question. So it's a good question, but not a straightforward one, because I think you need to understand the context within which you're using the information on that business card. So I think with that, thank you for all your questions. Thank you for staying with us the full hour. And I would like to hand back to Hitam to end the session. Thank you very much.
Thank you, Lena. Thank you, Janice. So yeah, we again, as the ICT committee, we've put this event together. Some of the other events that are coming up in the chamber are flashed up on the screen right now. So on the 1st of July, we have the essential tax planning for UK inheritance and inheritance tax and domicile. There's a virtual quiz and music evening. I believe that's that was launched recently, so please do sign up for that. And the green bonds carbon offsetting on the 13th of July. Another housekeeping, you will receive an email with a survey. Please, could you give us some feedback? This video will be put up on the BritCham website as well. So again, if you've missed some of the slides, refer back to the website, and of course, reach out to Lena, Janice, or the chamber if there's anything. Thank you for your time this morning.